Good evening and welcome to episode 383 of the Private Property Podcast. I'm your host, Nwoko. It's a Friday edition of the Private Property Podcast. If you join us for the first time, welcome to the family. You're tuned into the only daily property podcast in South Africa, helping you on your property needs. And to all our regular viewers on Facebook, on Twitter, on Instagram, as well as on YouTube, welcome to it. You know how we do. Every single weekday, you and I have an appointment at 7 p.m. where I'm always in conversation with property experts who help us navigate our property journey. And it doesn't matter where you are along your journey, we're certainly here to help you out and to make sure that you make the best informed decisions. And talking about the best informed decisions, you also know that we've got other great shows that you can decide to tune into every single weekday at 8 p.m. right here across Private Property's social media pages. As it is a Friday, you can catch Chad on the Home Shoppers Show, where he's on your screens on Mondays at the same time and takes you through exquisite properties that you can find on www.privateproperty.co.za. And every Tuesdays and Thursdays, Nwoko takes you through the farming podcast, tackling all things agriculture. And every Wednesdays, Esty Carson brings you the first-time home buyers show. She's always in conversation with people who've not only walked that first-time home buying journey, but have gone on to grow their property portfolios from strength to strength. Well, those are the great shows that you can look forward to every single weekday right here on the Private Property social media pages, rather. And of course, there's myself, Nwoko, every single weekday at 7 p.m. You and I certainly are together. And I want to see who's watching us live. Drop those green hearts down here below, regardless of where you're watching us. And of course, if you're watching us on Facebook, one of the great things to note with Facebook is that we're running a great competition where you at home stand a chance of walking away with 500 rands in cash every single evening. And all you have to do is to make sure that you comment on the pinned post on our Facebook page, where you share with us some of the great property insight advice that you've picked up while watching the show. And you have to make sure you're watching us live, because if you call your name, you have to drop us a text in order to claim your prize. If the winner doesn't claim their prize, the money rolls over into the money bag. That's exactly what's been happening for the past 2 evenings. We've now got 1,500 rands in the money bag. I hope whoever wins this money is watching us this evening and can end off the weekend on a high. Well, those are some of the great things that you can look forward to right here on the Private Property Podcast with myself. Let's kickstart our conversation this evening. And this one is the one that we have very regularly, because we know that not a lot of people understand this process not a lot of people still have firm grasp of what to expect when it comes to the conveyancing journey. And this evening, we're going to be looking at the basic principles of the conveyancing process, and also just looking at some key terms that you always need to be aware of, and even things that could potentially make a transaction take longer than it should, that you should be aware of from the get-go. And to help us get a good sense of how we can do this, we're joined by Alison Wright from DDT Attorney. Alison, good evening, and thank you so much for joining us this evening.
Thank you so much. It's a pleasure to be here.
And it's such a pleasure to have you with us on the show, Alison. I think let's start with, conveyancing. We talk about conveyancing. What are we talking about? I mean, so many people who start their property journey typically don't know, about a conveyancer. Sometimes you know that there's an attorney who's going to be involved in the property transaction, but you're still not quite sure how it's going to unfold. So when we talk about conveyancing, what exactly is it that we are referring to?
Well, conveyancing is a field of law dealing with all things property. But more specifically, it is the registration and the execution of a number of property transactions in the deeds office. And so when we look at conveyancing, there are two pieces of legislation that deal with conveyancing. That is the Deeds Registries Act and also Sectional Titles Act, along with a number of other legislative acts. But what it comes down to is there are certain transactions that are executed in the deeds office, and conveyancing is the entire process that gives effect to that. So whether that is the transfer of property, bond cancellation, bond registration, servitudes, limited real rights, if you're looking at township establishments, registration of sectional title schemes. So it is a very specialized field of law that deals specifically with property transactions. Yeah, so that's just a brief introduction to that.
And I think, the big thing to note there is if you're going to be dealing with any property transaction, you're not going to be able to do it without a conveyancer involved, because we've seen far too many instances where, somebody says, I'm selling my property, or I'm selling the family home in a township, and I'm just going to have an affidavit signed and give you my title deed. Unfortunately, it doesn't work like that. You absolutely cannot eliminate a conveyancer being part of that transaction, because there's certainly certain things that you and I at home won't be able to do in order for that property to exchange hands or exchange ownership from one party to another. And that's a really big thing that we need to take note of. And I can already see that we're getting some love on our Facebook page. Many of you watching us and sending through those green hearts. Do keep sending them. Kylie Shashabangu, Bongani, Queen B Mabonda. We've got Anelda Everton. And we've also got a first timer, Tony Melman, saying, hello, my first time here. Welcome to the family, Tony. I'm sure you're going to be very, very comfortable. I think all of us at home must certainly give Tony some love. That private property love, he must feel the love, because we know that we absolutely love making the circle bigger right here on the show. And now, Alison, when we look at then the role that a conveyancer plays in a property transaction, at which point is somebody who is either buying a property or selling a property approaching a conveyancer? Because I'm sure some people at home may be confused about, okay, I know that this is an important part of this puzzle called home ownership, but at which point exactly is a conveyancer then getting involved if you're looking to buy a property or if you're looking to sell a property?
Okay, so I want to touch on something you said earlier. I think it's so good that you are just warning people about the pitfalls of dealing with this process on its own. Previously, I mentioned the legislation that's applicable to the conveyancing process. And in terms of that legislation, a conveyancer is the authorized and qualified party that can execute these property transactions in the deeds office, and any transaction executed without that will ultimately leave purchasers vulnerable and unprotected. So I really do want to encourage people that if you are entering into these type of transactions, to make sure that you are using the right avenues. As to how you would approach a conveyancer, so usually when you sell a property or when you purchase a property, there's an offer to purchase to be signed, meaning that the parties enter into an agreement. And standard terms of those agreements, unless agreed otherwise between the parties, is that the seller is entitled to appoint the conveyancer. So the seller will decide, this is the conveyancing firm that I want to work with, or the conveyancer that I want to work with, and that I want to have this process with, and to have a transfer registered in the end. So that's ultimately how you would get there. Many estate agents do have certain law firms that they are closely associated with. So that might also be an avenue to get in contact with the conveyancer. But ultimately, once that offer to purchase is signed, then instruction is given to an conveyancer to deal with the matter.
And I want us to look at the offer to purchase, Alison, because I think, OTPs are synonymous with sometimes having a few issues. It becomes a very intimidating contract, especially for the buyer. With many of them, it's the first time that you're signing, a contract of that nature. Some of them thinking they can pull out at any stage, and we've had this, conversation before, just warning people at home that by the time you sign that OTP, it's a legally binding document. So you need to be aware of. I think if you can just share with us perhaps some of the mistakes buyers in particular make when it comes to the offer to purchase, and when they sign the offer to purchase, that they often realize retrospectively things that they were not aware of. And obviously by then they would have signed the contract, it's already legally binding. In some instances, you're able to have a conversation with the estate agent to speak to the seller, but in other instances they may not be as understanding to make those particular amendments.
I would definitely, like you said, encourage purchasers and sellers alike to really take the time and go through an offer to purchase. It shouldn't be something extremely complicated. A party should be able to go through that offer to purchase and understand, oh, okay, what is the effect that it's going to have on me? And if they don't understand something, I really do encourage them to make sure that they ask the right people and find out exactly what the consequences would be of that. Because definitely one of the most important things to consider is the enforceability of that contract. The moment the parties agree, that is the moment it's legally binding, and that contract can then be enforced. So, and of course there are legal consequences to that. So that's very important. So I think just briefly taking maybe a step back, when you decide to purchase a property, that's of course a process you need to embark on your own. You need to decide, what is my budget, what loan approval I might be suitable for, what am I looking for in a property. And then once you find a property, it's a back and forth between the asking price of the seller and what the purchaser is willing to pay. And once the parties have gone back and forth and really reached an agreement, and that agreement is signed, then of course it's binding. But I want to encourage people that before that point, things to consider is definitely financially, what are the implications for me? What is the greater costs of this? And then also looking at that property. A standard term in offers to purchase is a footstewards clause, which means that the property is sold as is, with its latent and patent defects. You are indemnifying the seller against any claims for any damages with regards to the property, because it is your responsibility as the purchaser to make sure that you go through the property, that you identify any problems that there might be. And it might also be a good idea to appoint a building inspector to help you consider more specialized fields of the building, let's say structural defects or water damage or any of those types of risks. It is important to know that yes, there are exceptions, definitely from the seller's point of view. If the seller is deliberately concealing certain defects with regards to the property, with the intention to defraud the purchaser, that is obviously a red flag, and the purchaser will have recourse in that regard. But I would also then just encourage sellers to protect themselves by really being transparent in this process, to say that, listen, this is the purchase price for the property, and with that, yes, there are these certain problems that you need to take note of, and to be transparent in that regard, to protect themselves against future claims and to protect themselves against certain future disputes. So definitely from both parties' sides, transparency is good, and really just doing your homework to find out what it is you are actually purchasing. So yeah, that's just a few of the things, yeah.
I am this evening in conversation with Alison Wright, who's from VDT Attorneys, and we're looking at the basic principles of the conveyancing process. And of course, joining us, I want to find out from you at home, your process when it comes to dealing with conveyances, when you are either buying your property or selling your property. Was it a pleasant experience? I know that some of us sometimes have not so great experiences with some attorneys that we've dealt with, but some of us we've actually had really good experience. I've taken a stance. There's a firm that I use fairly regularly with a lot of my transactions, and sometimes you want that. Once you get used to a particular firm, that's the firm that you kind of becomes your firm of choice when it comes to your property matters. I wanted to go for a quick break to find out who the lucky winner of that 1,500 rands that is in the money bag. And when we come back, we're going to be looking at some of the key terms and concepts that both buyers and sellers need to be aware of. Alison has already touched on one, the footstools clause, and we've touched on this, on a number of different occasions. And it always is one of those things that will keep going back, because we need to be aware of what it means and the limitations that it of course has. But in the meantime, let's take a look at who the lucky winner of that 1,500 rands is. And that lucky winner this evening is John Ishmael. John Ishmael, congratulations to you. You walk away with 1,500 rands right here on the Private Property Podcast with myself, Nwoko. Hope you're watching. Drop us a message down here below to claim your prize. And of course, if John doesn't claim his prize, then we're going to have a rollover into Monday where 2,000 rands will be up for grabs. But for now, 1,500 rands is up for grabs. Let's see if John is going to claim that money before the end of the show. And continuing our conversation as we're looking at the basic principles of the conveyancing process. Alison, when we look at, what are some of the key terms that both buyers and sellers should be aware of, especially even as we sort of look through the offer to purchase, because they're really going to be key terms that you always need to be aware of. One of them we've already touched on is the footstools clause. Perhaps take us through a few others that we always have to be mindful of as we're going through that offer to purchase and signing it, that we are aware that these are certain parts, the signaling parts where this is important. Take note of this part in an offer to purchase.
Well, I would definitely say in an offer to purchase, both the seller and the purchaser need to take note of those terms that really place obligations on them. So for the purchaser will look at how is the financial aspect of this transaction structured. They need to be wary of the deposit that they will be required to pay in advance to secure the property. They would also need to be aware of how are they going to secure the purchase price of the property? Are they going to do it cash? If it is a cash transaction, what guarantees are they able to give with regards to the purchase price? Alternatively, if they are going to secure it by means of a loan, they need to keep in mind that there is a requirement on them to obtain loan approval within a specific time or in a specific amount. And that is usually a suspensive condition of a contract, meaning that if the purchaser then fails to obtain that loan approval within the time specified, the agreement will become null and void. So that is, for example, something that the purchasers should look at. Whereas the seller, on the other hand, might also have certain obligations with regards to the contract, such as making sure that the electrical compliance certificate is in place and that the gas compliance certificate is in place. Another thing that the seller should note is just to be realistic with regards to the timelines of this contract. One specific example is if this offer to purchase is subject to sale. So if the purchaser has an existing property that they first need to sell before they can purchase this new property, that is something that can really delay the process for the seller, and something that they need to be aware of and realistic about, because really the process is then a double transaction that needs to take place and everything needs to happen on two fronts. So definitely something that can delay the process for the seller. So that's also something I would suggest that just keep in mind to look at.
We're taking your questions and comments this evening on the Private Property Podcast with myself, Nwoko Khumalo. As we look at the basic principles of the conveyancing process, we've got Umenzi Buthelezi on Facebook asking, can't the issue of being rushed into signing a contract be seen as duress or undue influence? And Alison, this is when, estate agents sometimes almost will, and I say almost, even though I think as a purchaser, you may feel like you were being pressured to sign, but it almost effectively pressuring somebody to sign. Mm-hmm. Is that something that can be, viewed as duress or undue influence?
Well, I definitely think it's important to know your rights in terms of the Consumer Protection Act. So parties entering into an offer to purchase are protected under the Consumer Protection Act. And in terms of the Act, there is a cooling off period. So if you feel that you were pressured into signing a contract for the purchase of property, there is a period of 5 days that you can utilize to cancel that contract, to say that, you know what, I feel like I thought about this a little bit, I'm having buyer's remorse, I'd rather step back and not go forward with it. So on the one hand, important to know what you're getting into, and I encourage purchasers not to be pressured into transactions. I do feel that is something we see a lot, especially when that estate agent says there's a lot of competition and there's a lot of offers and you might lose this property, you won't get a deal like this again. I encourage you, stay cool, calm and collected, but know that the Consumer Protection Act can also protect you in that regard, to say that while you have a cooling off period, to just think about things. So use those 5 days. And
Alison, yes, correct me if I'm wrong. If I remember correctly, the cooling off period, isn't it for properties? I think it's is it 250,000? So there's an amount where the cooling off period is applicable, if I remember correctly. Because I think, is it a standard cooling off period for all amounts, or it is, I know, for instance, for properties that are valued or going for under $250,000, then the cooling off period applies?
To be fair, I'm not entirely sure. You're asking me a trick question. In my mind, if the Consumer Protection Act applies, then that cooling off period does also apply. Bearing in mind that the Consumer Protection Act protects natural persons, not necessarily juristic persons with a turnover of more than 2 million rand. So to my knowledge, I stand to be corrected. That might be the case, but not as far as I know at the moment. As far as I know, it is a standard term in a contract. But it's a good question.
And we've got another one here coming through on YouTube, Tiatu Munyai, saying, what are the documents you collect in order to submit to the deeds office for registration? Love this question. So I think as conveyancers, you do this one quite a bit. So what are those documents that you ultimately have to have before you, before you take, them obviously to the deeds office for registration?
Okay, well, there's what we call certain documents in preparation for lodgement, and then there are your documents that you lodge in the deeds office. So firstly, most importantly, as with anything these days, FICA documents are always applicable. So those are documents that your transferring attorneys and your bond attorneys will collect from you as required by law. So those are the first things. Secondly, there are certain documents that need to be signed in preparation for the transfer of the property. One of the most important being the power of attorney, where the seller authorizes the conveyancer to act on their behalf to lodge the matter in the deeds office. But if we are looking technically at what documents are we lodging in the deeds office, not necessarily other documents important for the process, those documents will be that power of attorney that we spoke about, where the seller is authorizing the conveyancer to act on their behalf, to appear before the registrar of deeds to transfer the property. Then also, in order to do this, any property transaction, you will have a deed. That is your deed of transfer or your title deed. So you will have an existing title deed which protects your rights with regards to the property, saying you are the owner of this property. That existing title deed will be included. Then you will have your deed of transfer. That will become your new title deed. So that is the document that we will be using to say that this property belonging to A is now being transferred to B for this amount. So that's your third document. Fourth is your rates and taxes clearance certificate. So we are required to apply to the municipality in the area for a rates and taxes certificate. So we get clearance figures. The seller will pay 3 months rates and taxes in advance. And once they do that, the municipality will issue a clearance certificate, which we are required to lodge in the deeds office. And then the final document will be a transfer duty declaration to say that transfer duty has been paid on this property. Alternatively, a transfer duty exemption certificate to say that transfer duty is not payable. So those are your general documents. Of course, if you have more specialized transactions, then those will also be applicable. It is necessary to say at this point that those are just the documents necessary for the transfer. If you're registering a bond, there are additional documents for that we need to lodge. So that will be the new bond to be registered as well as a power of attorney. And then a bond to be cancelled, we will have a consent to cancellation that also needs to be lodged. So like I said, just some general documents, but there can be more specialized documents depending on a case-to-case basis.
And going to more of your questions and comments this evening as we continue our conversation on the basic principles of the conveyancing process. Coming to our rescue there on Facebook, Sarita saying yes, the cooling off is for properties under 250,000. Thank you there, Sarita, for confirming. Mgateko Achata saying most people become too excited while viewing and completing the offer to purchase. Then a few days later they sober up. Unfortunately, most of us sober up when it's too late and penalties apply. And that's a big one. Penalties will apply. So you want to make sure that you're not signing something that you may ultimately regret. A question here coming through from Uros and Zwane asking, is it wise to purchase or put an offer to purchase without being physically there to make those necessary assessments? I'm asking this with regards to people who are residents of the Republic of South Africa, but are working abroad for an extended period of time. So any tips for people, South Africans working outside of the country looking to buy property before they sign that offer to purchase, the best ways that they can effectively make sure that they're also protected and not buying a property that has issues that they obviously can't see physically?
To be fair, I mean, that risk is on them. Buying a property from overseas, that is a risky thing to do. So not something I would advise someone to do. Yeah. But of course, there are parties that can assist you in this regard if you have a trusted family member or colleague, someone you trust in South Africa to go and at least look at the property. More specialized parties like a building inspector can be appointed to go have a look at that property and to compile a comprehensive report of sort of what is the state of the property and what should you expect, what are the shortcomings. So there are definitely options, but I think it's best to do that yourself just to be safe. But of course, I understand it's not possible for everyone.
And listen, I think when we then look at the conveyancing process holistically, perhaps just give us a time frame of how long it typically takes. I mean, I've had a couple of matters in the past few weeks. Some have been very quick. One wasn't as quick as others, and it was because of the nature of the application. But just to give us the average, time that we should almost budget from the moment that offer to purchase is signed right through when it's going to be up for prep and ready for lodging at the deeds office.
Well, we look at a time frame of about 5 to 8 weeks, but that is, of course, generally speaking. Things that can possibly delay that is if we are, for example, dealing with estate transfers, so property that is transferred from a deceased estate will always take longer because the master's office needs to consent to that. Like I said earlier, if you are dealing with property that specifically is subject to sale of a foregoing property, that will also delay the process. Also, generally, just important to keep in mind, if you are purchasing a property from the plans, of course, if the building needs to be built first, it has to be completed. And sometimes that can take a year to get to that point, even longer. It just depends on the circumstances. And then finally, the problems we find most is if there is a problem with the municipal account at the municipality. For example, just something, outstanding amounts or discrepancies or information. I mean, there are so many strange things that can happen. And just the going back and forth and following up with municipal departments, that can really delay a matter. So generally 5 to 8 weeks, but like I said, it always depends on the matter.
And Alison, before we wrap up this evening, any final tips for our viewers at home when it comes to them firstly just best understanding the conveyancing process, whether they're looking to buy or of course looking to sell, that can best help them navigate or certainly walk the buying or the selling journey going forward?
One of the things that we haven't really touched on, and I think we're running out of time a little bit, but is really understanding the costs involved for both parties. If I can briefly just go over them, sellers must always keep in mind that there will be estate agent's commission applicable. Of course, if you are working with an estate agent. So if you are looking at your purchase price, just always bear in mind that a cut of that purchase price will also go to an estate agent, just to prepare yourself for that type of thing. I mentioned earlier, sellers also need to keep in mind clearance figures that need to be paid to municipalities, levies that need to be paid to body corporates. If there are any compliance certificates that are required, the seller will be responsible for the cost of that. For the purchaser, many costs involved. So it's important that they understand that going into things, I think that buyer's remorse definitely kicks in the moment you see all those costs. And so definitely just to touch on a few of them, there is the transfer duty, so the tax to be paid when a property is transferred from a seller to a purchaser, unless the seller is registered for that. Then there's the deeds office fee for the registration of that transfer. And then there's also just the conveyancing, the transfer attorney's fees for that transfer. If they are financing it by means of a bond, there's also going to be bond registration fees applicable. I don't think we have enough time, but also just some costs that you need to take into account with bonds. The initiation fee applicable to all bonds, doesn't matter who you bank with. That's a 6,035 Rand fee that is payable as well. Occupational rent. If a property doesn't register before a certain date, you might be required to move into that property and to pay occupational rent for a certain period of time before it does in fact register. So that's just another example. I just quickly want to think if I'm missing anything. Just hopping back to bonds, many banks require you to take out property insurance, which is another monthly premium.
Yeah.
Yeah, a monthly premium you need to think about. And some banks even require you to have credit life insurance. Life insurance that pays out to cover your debt should you die or disability or lose your job, etc. And that can also be a monthly premium that you didn't necessarily think about when you saw the property and fell in love with it. So I think my biggest tip would be consult with someone just to say, listen, outline the possible costs for me. What am I looking at? And keeping that in mind when you start this process. I think that would really be my biggest tip. And just doing your research beforehand of what this process looks like to really manage your own expectations, but also to give you that peace of mind in this process and to make it a celebration, because it is exciting. I think it's a dream for many people. It's a dream for myself as well. So yeah, to just enjoy it, but keep an open mind and just know what you're getting yourself into.
And it's just such an important one. I think those costs stack up. And of course, with transfer duty, if you're exempt if it's under $1 million, but anything over that, you know that you're going to pay, so you have to budget for it. You can use the calculator on the private property website to get a sense of how much the transfer duty would be if you're going to have to pay for it, and all these associated costs. There are different calculators on our website that you can use to get a good grasp of how much you're looking to spend. I'm going to squeeze in this last question. It's a great question coming through from Cedric Yonkers, and it actually touches on something that you even mentioned earlier, Alison. And his question is, in the sale of a property in a deceased estate, a Section 42(2) certificate from the Masters of the High Court is required. Who's required to pay for that, the seller or the buyer?
Sure, that is an interesting question. I'm trying to think. Usually your purchaser is required to pay any transfer fees that is applicable, like we just discussed. So I would say I would just consider whether there are really costs involved with that